I'd like to talk to you a little bit about the concept of jurisdiction. Jurisdiction is essentially the a consideration, if you would, that we have to make to determine whether or not a particular court has the power to determine the outcome in a particular case. Jurisdiction comes from the Latin root juris, law, to speak the law. Jurisdiction, juris doctorate is the degree that an attorney gets. And you can see that I've provided you a bit of a dictionary definition as well. It really equates to judicial power. So let's take a look at the three factors that go into determining jurisdiction from a legal sense. The very first factor that would go into the jurisdictional analysis is something called personal jurisdiction. This jurisdiction pertains to the person or thing involved in the lawsuit. The second aspect is subject matter jurisdiction. This would determine whether or not the court has power to resolve a particular case or controversy. And the third prong is territorial, or you might hear geographic jurisdiction, which for an attorney really equates to a concept called venue. And I see my little jurisdiction dropped out there, but you'll remember that that's at the top of the slide. I think it'll come back in a moment. So personal jurisdiction really has two different sorts of analyses. One has to do with in personam jurisdiction. That means jurisdiction over a physical person or an entity or an organization, something with the capacity to sue or be sued. Then we have in rem jurisdiction that pertains to property. So in personam jurisdiction typically means we're looking at situation where we want to determine whether we can obtain power over a particular person. And usually that involves one of two tests. Either the person is physically present within the forum, and that would be the test of physical presence. That's an easy one. I'm sitting in my home, and therefore I am physically present in the state of New Jersey. Or if there is physical presence is not available, we then look to something called minimum contacts, and that is for out-of-state defendants. We determine whether or not the defendant had the requisite or enough minimum contacts to anticipate being hauled into court in a forum state. The minimum contacts test would probably take me to a few different jurisdictions that I have some sort of minimum contact with. Off the top of my head, I'm thinking of my consulting business pursuits, which would potentially take me to Illinois and Georgia and Virginia and New York. You ordinarily will look for jurisdiction over a defendant, and that's a pretty good reason to think of if a plaintiff has chosen a court to file, because you learned in the litigation process that the plaintiff initiates the lawsuit with the filing of the complaint. It would be really silly if a plaintiff initiated a lawsuit in a particular court and then told the court that the court didn't have jurisdiction. Yeah, that would just be silly. And so ordinarily we're just looking at the power that the court might have over a defendant. And then, of course, we have in rem jurisdiction. This gives the court a power to decide issues relating to property. You might find a tax case or a seizure case, maybe even where an owner isn't known. That would be an in rem case. It would be, I don't know, the Borough of Highbridge versus 123 Main Street. And so you would say, well, what did 123 Main Street do to you as the defendant? It really is a property action. The jurisdiction comes relating to the property, and we get that jurisdiction by finding that property within the geographical boundaries of the forum state. And so let's take a look at my friend here, subject matter jurisdiction, where we actually have three prongs. The first consideration is whether we're going to state or federal court. And the second one is whether we're looking at original or appellate jurisdiction. And then my third one has to do with whether the case is a general case or limited or special. You might see unlimited versus limited, or general versus special, or general versus limited special, all of those things interchangeable. And so for subject matter jurisdiction, certain cases can go to federal court. there are actually two types of cases that go to federal court. And those cases are, and I think we're going to see them on the next slide, federal question cases, cases that raise a federal question. For instance, if you want to sue somebody over under the federal code that relates to employment discrimination, then you could go to federal court. And then also relates to something called diversity jurisdiction, wherein we have citizens of two separate states litigating against each other, and the amount that is in controversy is in excess of $75,000. I'm just fast forwarding to this information. There it is. So again, federal question jurisdiction has to do with the rights, the federal rights of parties. And in diversity cases, we're looking for parties from different states with an amount in controversy in excess of $75,000. All right, just going back here for a moment. Okay, whoops. There we go. Alrighty, so every once in a while there's a technical glitch, but that's okay. We have general or unlimited jurisdiction, and then we have limited and sometimes called specialized jurisdiction. Here in New Jersey, we have general or unlimited jurisdiction courts. There are civil and our criminal division. We also have a few examples of limited jurisdiction courts. Those would be our municipal courts and our special civil part, which is equivalent to what you might think of as small claims, although many people don't know that we call it special civil part here in New Jersey. We do. And then we have something called original versus appellate jurisdiction. Original jurisdiction is the trial court, the court of first resort, the first stop. Appellate jurisdiction tends to be a reviewing court. The appellate court has the power to hear an appeal from the other court and do something with it, reverse it if they believe the lower court was incorrect, affirm it if they believe that the lower court was correct, or modify a decision if the lower court was abundantly correct, but they got a few minor things wrong. Sometimes the decision can be modified. And we talked about the federal versus state. And so, subject matter jurisdiction pertains to a choice. You have to choose kind of one from each of these columns. If I could, maybe I might have a case that's a state case in an original jurisdiction court, and it's a special civil part case, so it's limited or special. So let's get on to territorial jurisdiction, also called venue. What does that mean? Well, in a question of venue, we've already determined whether or not this is a state or federal case, so we're not necessarily looking at the state venue. Instead, we're looking at the geographic location within a state. For instance, a county where the particular case will take place. Usually, we're talking about a situation where we're determining where the injury occurred, and that would be the most appropriate place to venue the case. In a situation where there are two competing venues, maybe the injury occurred in multiple places, or maybe a venue where there is a situation where the particular injury didn't occur there, but there is quite a bit of evidence in that venue, a judge can pick between those venues. So it's not necessary that there is only one venue. However, there could be a best venue, and that would be where the injury occurred. So before we leave this discussion, let's take a quick look at how the particular court systems are set up. Over here on the left of your screen, let me go ahead and put out a pointer. Let's see, we'll do some fellowship. On the left of your screen, this is the federal system. And on this side, in the green side, this is the state system. A lot of times, especially in my private practice, my clients would think that you can crisscross between these two like this, but you can't. You cannot crisscross between those two. So you either go up one side or you go up the other side. And they do meet at the top, and that's the only time you can crisscross. So let's go up the federal court system first. You've got our United States District Courts, and they are the courts of general jurisdiction in the federal system. And then there are some specialized U.S. courts. We talked about the specialized ones, let's say on the New Jersey side. On the federal side, a good example would be the bankruptcy courts. The district courts sit with a trial judge, and if the person who lost in the district court would like to appeal, they then go to the United States Courts of Appeals. The United States Courts of Appeals tends to hear cases with a three-judge panel. Every once in a while, they sit in a manner that's called en banc. I'll write this down here. En banc means every single judge on that court will sit and listen to that case. So the most judges that I've ever read on one particular opinion were 15, but that's very atypical. Normally, it would be a three-judge panel. 3-0 would win, and 2-1 would win, and 1-2 obviously would lose. And if the loser is still unhappy, or it's a new loser at the United States Court of Appeals, you can appeal all the way up to the United States Supreme Court in the federal system, where we have 9 judges, or justices, I should say. Going up the state system on the green side, we'll again start with the court of first resort. That would be our superior court. That's the trial level court. We do have inferior courts here. The municipal court depicted under the superior court because it is inferior to the superior court. The tax court kind of on the same level as the bankruptcy court would be in the United States District Court. We then go up to the next level. Here in New Jersey, we call our intermediate appellate court the appellate division. Again, typically 3 judges would sit and listen to a case, to an appeal, if a loser from the superior court decided to appeal. And then on up to the New Jersey Supreme Court. That's a discretionary appeal. That means that you make a request. The New Jersey Supreme Court does not have to hear your case. The appellate division appeal is one of right, but the New Jersey Supreme Court appeal is a discretionary appeal. And then if you lose at the New Jersey Supreme Court, you do still have one more shot. You can appeal to the United States Supreme Court, but only if the issue impacts federal constitutional law. And so that's why we hear so many criminal cases going through this process and making it up to the United States Supreme Court. But they didn't start as federal cases, they started as state cases. Good examples of those would be, for instance, Miranda versus Arizona, Terry versus Ohio, that's the stop and frisk case. Miranda versus Arizona is the reading of the rights case. And so that's how those cases got to the Supreme Court. The Supreme Court review is always discretionary. Well, for the most part, discretionary. There are a few cases they're obligated to take, and those can be found in the United States Constitution. Very few cases will be taken by the United States Supreme Court in any particular year. It's the good guess is less than 1% of the cases will actually be taken by the United States Supreme Court. And so I hope you feel like you've gotten a good exposure both to the concept of jurisdiction and the way in which the particular states function and way in which they work, and I'm sorry, the way in which our state works and the way in which the federal system works. And on the remaining slides in the course, you'll see some particulars about the New Jersey state system. All right, so go there, check it out. See you on the discussion board.